Good afternoon, everyone. I hope you are doing well. As you may realize, I've been entrusted with the new system. It is new and improved, but hey, we're going to see if I can pull this off and have a good time with it. As housekeeping, as you may know, my name is David Furman. I'm an attorney here with Altitude Community Law. Right now, you should see the PowerPoint presentation taking up most of your screen. It's on mine. It's like right there. It's kind of big in the middle. There should also be a small box on the left-hand side of the screen with the presenter, me, go for it. On the right side of the menu, you should also see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting, or quite frankly, as I decide to start responding to them. You guys know, anybody that's taken a class with me, I love going off script. Okay. If you have audio or video issues during the presentation, please click the No Audio or Video button below the presentation on your screen and follow the instructions. You'll have to do that on your own. I got no idea. All right, one CMCA credit will be automatically generated and emailed to you after the webinar, assuming you attended the entire program. Guys, at least leave your computers on. Sorry. Okay, these credits are not transferable. It has to be you that attends. All right, please email Summer Sims at SSIMS, that stands for Summer Sims, at altitude.law or call 303-991-2076 if you have any questions about the webinar or receiving your CMCA certificate. Lastly, probably not, there will be a survey that pops up at the end of the webinar. Please let us know what you think of the webinar. The webinar, not me, the webinar. You can email me later, tell me what you think of me. Your thoughts and opinions are important to us. So with all that being said, let's have a little bit of fun. And Rachel, we're going to get to that question, I promise. See, go off script. All right, again, my name is David Furman. I'm with Altitude Community Law, and this one is the annual 2023 HOA legislative update, which we could also deem like time through sand through the hourglass. These are the days of the legislative body that will continue to play with our lives and decide there are better ways to do things. Okay, with all that being said, which bills did not become law and why do we care? Well, mostly because about 5 years ago, I wrote a blog on something I called the zombie bills. They are bills that just would not die. They came back over and over and over and over again. That's why we care, because we get to see what the legislature thinks, what the legislative body thinks, and how they address certain problems. And you'll kind of see this theme come up at the end of the presentation. But also, this bill is going to come back. This SB 23-213, simply entitled Land Use. And the reason they titled it Land Use, in my opinion, is because Colorado has a single topic for its bills. A bill cannot change, once it's titled, it cannot change that topic, it cannot bring extra things in. When you have a simple title as Land Use, it was able to become a 105-page monstrosity that touched every single corner of the state of Colorado if it touched land. This was, in many people's opinion, mine included, a massive overreach by the state. It essentially would have put the control of the land planning in the state's hands. That they were required, this bill required the state to adopt land use codes. If you didn't adopt, as a local municipality, if you didn't adopt the state's land use code, they would come in and do it for you. Would have eliminated restrictive covenants on ADUs. You start to see that in some of the jurisdictions already, that if you have a provision in your governing documents that says no second houses on a lot, that would have gone away. It encouraged high density housing. It took off restrictions for considering parking when you build all these high density units. And it really was something that was intended to flood the market with housing. It was intended to drive the cost of housing down. It failed because of, again, it took on a lot of duties and put them in the state's hands and took it out of local control. And a lot of A lot of people just couldn't get their arms around that concept. I think the different local municipalities are more than happy to work with the state, but they don't want to be ruled by the state. So this bill also just ran out of time. It's not like it was vetoed. It's not like it was postponed indefinitely. Negotiations were continuing until the very, very end of the legislative session. They just couldn't reach an agreement. So in my opinion, this one's coming back and it's not going anywhere. We're going to have fun with it. We'll be addressing it again next year, because this housing in the state of Colorado is an absolute problem, and it will continue to be a problem until addressed. So as I mentioned, you're going to continue to see this, and there's not much we can do to get around it. Okay, next, a couple of the other failures. And HB 231131, in my opinion, again, was a problem in the drafting. And when it originally came out, it was a majority of unit owners required for association budgets. And it was meant to require approval of the owners prior to adopting a budget, as opposed to the lack of a veto, which you currently have right now. But the way the bill was actually started out is it said the association's board of directors could not adopt a budget unless at that board meeting, not owner meeting, at that board meeting where they considered and adopted the budget, a majority of all owners were present. So you would have had to have gotten a majority of all owners in the community present at a board meeting at which the budget was discussed and adopted by the board. That was quickly changed to require owner approval, and where the drafter really wanted to go, and just quite frankly, it's a very junior legislature, where the drafter of the bill really wanted to go was to require that the owners present at a member meeting approve the budget, not the lack of a veto. Yeah, I'm getting stuff that says I'm unstable. Hi guys, take just a second. Again, absolutely new platform. I'm learning. Yeah, it comes up there. It says my internet thinks unstable. Am I going in and out?
It's like the PowerPoint isn't working for
Why
some reason.
It's
So it
working
wasn't
fine.
showing up on my end.
Did you load it back up?
I did. Keep going.
All right, I've been told to keep going. If you have the PowerPoint, if not, we're going to get you the PowerPoint. I promise. It's coming. Let me see what you guys are saying to me, because I'm ignoring it, because I was told to do it at the end. Okay, it's working fine. You guys are so awesome. Thank you so much. So anyway, getting back to this bill, it really was one of those things where the drafter of the bill, or the sponsor of the bill, wanted associations to, whoever is at the meeting, that constitutes a quorum. So it would be the affirmative approval, regardless of how many people were at the meeting. That's who would be able to adopt the budget or approve the budget. I hope that through educating the particular sponsor of this bill, we find out that we can educate this particular sponsor and really let them know that the reason the bill is written the way, or the reason the statute's written the way it is to allow an association to adopt a budget and make sure that associations can still continue to conduct business. Because if we get rid of that, associations are going to have a really hard time adopting a new budget. The other one that was killed right away is 231127, and it was titled "The Right to Use Energy." And really the only change that would have mattered to us in the association industry is it allowed what were referred to as micro dams. So essentially, and the only place I could see somebody putting a micro dam on their property is if they dammed up one of their own gutters, put a little micro generator, and ran a battery or ran a power off of that. But if you had water running through your property, you could put a little micro dam on it. It was killed relatively early in the work, so I didn't get a good handle on what the sponsor of the bill was really trying to accomplish. But again, it furthered the state's green agenda. of really getting renewable or energy efficient ways of conducting business. So those three bills were the failures. Didn't get through. 1131 and 1127 were postponed indefinitely. I don't know if they'll come back. The land use bill will come back next year. And I know a lot of associations were absolutely beside themselves with the provision in it that said it would remove any restriction on second units on a lot. That was removed from the final bill, so we'll have to see if that comes back. All right, here we go. The task force. This is what passed. And we're going to dive deep into this because this one is going to be around for a while. And you're going to start to see language, as I mentioned, in this particular statute that created this task force to, again, see where the state is working. And if you look at how this bill was drafted, okay, it talks about who's on the task force. And it talks, so Sarah, it looks like if you try and refresh your no audio or video button, it'll refresh the PowerPoint. So getting with the, kind of getting into the purpose of the task force, it is to...
Hi, if they can't see their PowerPoint, tell them to choose the use other video option at the bottom of the screen.
If you can't see the PowerPoint, use the other video option at the bottom of the PowerPoint or at the bottom of the screen. And if I can pull this off, it says enable blur, disable audio. I don't know which one it is. It must be a button you guys have.
It's a second.
It worked. Great. Get out. Okay. Thank you so much again, everybody, for the status report. Okay, here we go. And I do thank you all for being so patient with me as I work through this. This is the first time I've used this. It's only the second time that the firm has used this. So we will work out these bugs, I promise. Anyway, getting back to the task force. Okay. So if you look at what the task force is directed to look at, okay, it is directed to look at shall examine issues confronting HOA homeowners and homeowners' rights, including the following authority and practices: finding authority and practices of associations, foreclosure practices, communications with homeowners regarding association processes, and HOA homeowners' rights and responsibilities. How do we educate homeowners? What are homeowners' rights? How do we handle what they deal with? This bill is very homeowner centric. Okay. The committee or this task force is appointed of the following people. It consists of the director of the division of real estate or their designee, the director or division of housing, the HOA information officer. The Speaker of the House gets to appoint 2 members, one of which must be a board member living in an association, and one of which must be from a disproportionately impacted community. Now, a disproportionately impacted community is defined by statute as being, based on census data, 40% minority or 40% low income. That is what is defined as a disproportionately impacted community. So there will be somebody on this task force discussing issues that they face in their communities. An HOA advocate, somebody from like CAI, an attorney that represents homeowners in lawsuits against associations, a member of the House, and a member of the Senate. That's who gets to be appointed by the Speaker of the House. This bill was redrafted. As it was originally drafted, the governor had absolutely no authority in appointing anybody to this task force. This was added to the bill. Now the governor gets to appoint an HOA attorney or an attorney whose primary practice is in HOA law, a developer, a manager. That was actually left out of the original bill, is trying to find a manager and appoint them to the task force. What does this task force do? Well, as I mentioned, They're going to meet as early as practical after all members have been designated or appointed. And it is set up to be, they're meet as early as practical. An association is required to notify their owners about the existence of the task force. So if you are required to inform your owners in the community of the existence of this task force, I would have to think, and Mary, to your question, will the meetings be open to the public? They should be. They are public meetings. These are meetings of a legislative body that is going to start talking about issues facing the state of Colorado. The task force shall examine issues confronting, as I talked about, homeowners' rights, fines, foreclosures, communications for each association in a representative sample of associations in the state that the task force selects. The task force, as I mentioned, it has quasi-subpoena power to demand HOA documents. They get to pick a sampling of associations in the state of Colorado on how they make their declaration, their bylaws, their articles of incorporation, how they make their rules and regulations, responsible governance policies, any other policies that the executive board of the HOA adopts, financial statements, and any other of those documents. How do they make them available to the owners? So they can go to a sampling of the associations in the state of Colorado and demand information on how they make these documents available. The task force shall also review HOA homeowners' complaints as reported to the HOA Information and Resource Officer. They are required to examine the Colorado Common Interest Ownership Act and how it works. They are required to examine state laws regarding common interest communities. My guess is they will look at California's Davis-Stirling Act and the Florida Condominium Act. My guess is that's where they're going to go, because those are kind of the big states that are not Kiowa states, which, if you're familiar with how some statutes are drafted, there's a Uniform Common Interest Ownership Act. It's what Kiowa was based on. Kiowa stands for the Colorado Common Interest Ownership Act. So the legislatures in 1992 took the Uniform Act, tweaked it a little bit, and made it our own, called it the Colorado Common Interest Ownership Act. They have to go look at the Uniform Act and see how it has evolved, see what is good in the act, what's not good in the act. And my guess is you're going to start to see a major overhaul of the Colorado Common Interest Ownership Act. Representative Titone has stated she would like to replace Kiowa with something. She doesn't know what, but that's a multi-year endeavor. So here's another kicker. The executive board of an association shall cooperate with any request from the task force for information regarding the association, including any request for the association's governing documents, financial statements, reserve studies, or records related to collection activity or legal actions the association has taken. An association submitting documentation to the task force shall remove all personally identifying information from the documentation before submitting it. The task force may only report on information received from an association in a manner that protects against the publication of personally identifying information of the HOA homeowners. So you as managers, this task force could come knocking on your door and say, hi, we would like your financials, your reserve study, your collection activity. We want a roster of everybody you have collected against. We want a roster of your foreclosure activities. We want a roster of all of this information, and you must provide it. You shall cooperate with this task force. And Joel, you made a comment of who pays for this. Well, the legislature appropriated money to pay for the task force, but who's paying for the documents they're going to request from the associations? The association is. You're going to have to go in, you're going to have to get these documents, you're going to have to redact homeowner information, and you're going to have to provide all of the information that the task force requests that falls into those wonderful parameters so that they can go out and they can get the information they're looking for. Congratulations, you now have a new task. Okay. We talked about who's appointed. We talked about the areas of focus. They shall report to the legislature by April 15th, 2024, which tells me that this really is not anything for 2024 legislation. This will be 2025 legislation and beyond. And that is really, I think, where we're going to start seeing, I hope that we can start to see a lull in legislation next year as this task force gathers all of its information, because it reports by April 15th to the legislature. The Metropolitan District Task Force has to do a final report to everybody in June of next year. So it's after the legislative session for 2024. So maybe we'll get a reprieve next year in HOA legislation. Expect big things in 2025. That's when everybody will have all of this information. That's when all these recommendations will be made. That's when we will know exactly where they're going to start targeting legislation in the future. Okay. Now, in conjunction with this, there is also a Metro District Task Force. And the Metro District Task Force is comprised largely of the same type of people. It is elected city councilman, an attorney that sues districts, a representative from a nonprofit that advocates for affordable housing. And again, we're going to talk about that at the very end. Member of the House, member of the Senate, an attorney specializing in metro districts, an attorney specializing in suing metro districts. They're going to look at the HOA report. They are required to look at the HOA report. They are also required to look at the processes that may be used to convert districts to common interest communities. If you recall, one of the things that developers started to do is they stopped building condominiums. They started building attached townhome products, not creating the association, but creating a metro district and authorizing the metro district to enforce covenants and do collections. It got around the creation of a common interest community because typically a governmental entity, a metro district, will not sue a developer in construction defect. So it worked really well. The legislature wants to see how we can get these back into associations. They are specifically tasked with looking at ways to bring these back into and convert them to common interest communities. They also want to look at foreclosure practices, taxing, mill levies. Their reports due before March 1st, and then their final reports due in June of 2024. So again, I really think we're not going to see much legislation next year, but this is where the legislature is focusing its efforts. This is not a cheap task force. It came with a hefty fiscal note. They are going to do a lot of work. They are going to review a lot of work. They're putting together their teams right now, and they will start looking at how to address some of these issues. Now, of course, one of the funny things that I did notice is everybody serving on these task forces is going to be a volunteer, except for the legislatures. They get to be paid. Isn't that just glorious? So anyway, that's where that bill is going. Kate, in answer to your question, the statute actually doesn't say how far back they can ask for documents. However, since Kiowa says 3 years on financial information, that's where I think I would start, is about 3 years back. They want to get into the stuff that happened in Green Valley Ranch. And if I was the Green Valley Ranch Association, I'd be prepared for a request almost immediately as to their foreclosure practices. But hey, I digress. Okay. Jillian, you asked, what are the requirements for notification of the task force? It just says you shall notify your owners prior to their first meeting. I would put it in a newsletter. I would, if you have annual meetings coming up, let everybody know, hey guys, there's this task force out there. Go look at it. And then if we can find a website for the task force, or maybe you produce the link to the bill. Maybe you produce the bill and just say, hey, this is out there, and let them do their own research. It should, like I said, you just absolutely have to tell them about it. And it's that one little statement in the bill or in the statute that says associations shall notify their owners prior to the first meeting. Notify them. And then that final report's June 15th, 2024. That's to the legislature. And again, that's after the legislative session. So 2025 is our year to watch. It'll be fun. Moving on. HB 231233, and this could have been the reason that everybody was having a problem with their PowerPoint, because I was a Muppet and had a typo in your PowerPoint. If you got this yesterday, it said 1133. It's not 1133, it's 231233. And this is, again, more of the state's green agenda. The bill does not say how the public is to know how the task force meets. But again, I kind of coming back, I will start answering these questions now that I've moved on. Let's talk about 1233, then we'll come back to all these other questions. I have it. I noted where my I left off. Okay. This bill does a whole lot of stuff. I mean, it's actually a really big bill spanning a whole bunch of pages. I mean, it feels like about 25 pages. There's one little section in it that matters to us as association practitioners. It amends section 38-33.3-106.8 of the Colorado Common Interest Owners Act, which addresses a couple things. Basically, what this bill says is, outside of all the other stuff that the government has to do and has to create site plans, has to do all sorts of stuff, how we're going to update the grid and how we're going to do the other, how we're going to make life better for electric vehicles. Last year, a couple years ago, EV charging stations became protected. And when EV charging stations became protected, there was a provision of, okay, where do they go? Well, and do you have to allow them? And the answer has now been answered, yes, and you can't really regulate where they park. So what it says is, an association shall not, A, prohibit a unit owner from using or installing at the unit owner's expense for the unit owner's own use a level 1 or level 2 electric vehicle charging system on or in a unit, okay, that's not a change, an assigned or deeded parking space that is part of or assigned to a unit. So if you have limited common element parking, if you have assigned spaces at all, you must allow an owner to install a type 1 or type 2 charging station in their parking spot. You can adopt rules regarding safety considerations. I know that there are going to be issues with power grids. I know there are going to be issues dragging electricity from one side of the community to another side of the community. So it may effectively prohibit itself because it has to be done at the unit owner's expense, dragging power from it, but you cannot prevent them from installing an electric vehicle charging station or system in a parking spot that they own or is assigned to their unit. And then this one, which I like a lot, and if we can tell me how we are going to deal with this, I'm all ears. A parking space that is accessible to both the unit owner and other unit owners. So if I, being a responsible electric Mini driver, want to bring in my electric Mini into a community that I own a unit, I can put a type 1 or type 2 charging station on a general common element parking space for my own use. Because remember, the bill says, prohibit a unit owner from using or installing at the owner's expense for the unit owner's own use a level 1 or level 2 electric vehicle charging system on or in a parking space that is accessible to both the unit owner and other unit owners. I can put in a charging station on general common element parking, lock it up, make it mine, and you can't stop me from doing it. I'm so excited. You're going to start to see these pop up all over the place. It'll be great fun. All right. And here's the other kicker. You can no longer restrict parking based on a vehicle being a plug-in hybrid electric plug-in or a plug-in electric vehicle. This came out of an association in a community that said banned vehicles from being parked in the underground garage due to fire hazards. They can no longer take that approach. So this is the changes to the statute. You can still charge a daily rate for charging of the electric if they're using common element power. You can still charge a meter or still require they put in a meter and pay for their actual use. But I think what you're going to see this be is it will be easier and more efficient if the association just takes the initiative and puts 3 or 4 of these charging stations in, and then you can charge, and then you can control it as the association, as opposed to just having these things popping up all over the place. Okay? All right, let's go. If the outside of a garage would be the board, if on the outside of a garage, would the board be able to control where it would need to be placed, or does the owner have the ability to choose where on the outside of an LCE that the EV charger is installed? I think you can adopt reasonable aesthetic controls and you can adopt reasonable safety controls, but if the owner can show that it should go here and it's safe, you're going to have to let them install it wherever they want to install it. Now, if it's actually a garage and the owner parks inside the garage, you can require it be installed in the garage. But these are for just like if you have a carport. If you have carports, I think an owner is going to be allowed to install these things on the carport. Okay, hang on. Let me go up just a second so I can go. On the outside of the garage, what about the cost of installing a meter? You can still charge the owner with the cost of installing the meter or require the owner to install the meter. Does this mean that an owner has to pay for the electrical use? Yes, you can still charge them for electrical use. You can charge a reasonable daily rate, or you can require a meter put on. Those provisions of the statute don't change. Does use also mean exclusive use? Sure does. If it's a limited common element that they have exclusive use of, they can install a EV charging station on it. The parking space on GC is not for an owner's exclusive use. The statute does not say exclusive use. The statute says a parking space that is accessible to both the unit owner and other unit owners. It does not say for their exclusive use. So I personally think the way this is drafted, I can install one and put a lock on it and make it mine. I may never be able to use the space because somebody can always be parked in it, but I can do it. That's the point. So again, in my humble opinion, what they are trying to do is force the association to start installing some of these. What about a clubhouse parking lot? That is common area parking. Christine, as I mentioned, the statute says a parking space that is accessible to both the unit owner and other unit owners. They can put one in there if they so choose. I'm not saying it's a good idea. And if a new unit owner and other unit owners actually get to use the parking space, I may never actually get to use my own charger, but that's not what the bill says. That is not what this statute that is signed into law says. It says, do I get to use it and do other people get to use it? I can put one there. Go me. Jason, to clarify, you have to allow the installation of the charging station, but there is no mandate to restrict access to that spot for the unit owner, correct? Correct. You don't have to restrict it to them. They can just do whatever they want. Like I said, I can install it and never get to use it. Isn't that so fun? I love these bills. I have so much fun, and you guys are going to have so much fun. What I really do think, though, again, in all seriousness, I really think this was drafted in such a manner as to require associations, to put the burden on the associations to try and get them, go out, get some grants, go out, install community chargers. You can put credit card chargers on them so they have to pay for their own utilities. You can contract with different companies to come in and install them for you. And there are the state, if you drive an electric vehicle, the state has now got electric vehicle plates or stickers that you are required to have on your vehicle to be able to park in a space where an EV charging station is. So you can start to restrict parking that way. And Mary, you have no idea how warped my sense of fun is. Anyway, okay, what if someone not belonging to the HOA comes in on site and charges their vehicle, then leaves? It's, again, getting back to, remember, the very first part of this bill says, for my own use, I should be able to lock it. So nobody should be able to come in and park in my space where I have decided to spend $5,000 to put a charging station that nobody can use, and I probably can't park there 90% of the time either. And it can't, Keith, it can't be. If it's an assigned space, it's mine. I can do what I want. It's the problem is that second section that says a parking space that's accessible to both the unit owner and other unit owners. what do you do with that? It's fun. So anywho, we're going, like I said, I think as boards, if you have a community that is going to be flooded with electric chargers, because again, or electric vehicles, if the association puts the stations in, John, that's where I was getting at. I really think the legislature, I really think what they want you to do is you put these in yourself, and that way you can charge and you can turn it into electric vehicle charging stations and not parking. Meaning you can absolutely have somebody come in, plug in, put in their credit card, charge, and then have to move their car someplace else to allow it to be available for electric charging, because there are rules about being able to park in an electric charging station. But if it is a general common element and I choose to install one at my expense for my use, you have no duty or you have no authority to make sure it's available for me. You just have to allow me to do it. Barrett, I'm not even going to address your comment, but thank you. Okay. Any other questions on this real quick, and we'll move on. This one, like I said, this one's sneaky, and this one's going to get you. So I would, like I said, if you live in a community where these are going to be becoming an issue, maybe start looking at grants, or maybe start looking at bring an electric charging station company to come in, install a couple of them, and then make it so that you can start regulating some of this parking. But that doesn't change the fact that if I want my own, I can install my own, but it's at my expense. And if I'm doing it on general common element, I have no guarantee that I'll ever see it again. But that's not your problem, it's their problem. Okay, moving on. Water-wise landscaping. This again gets to the association's, the state's absolute efforts to get out of watering lawns. And it wants you as associations to get out of watering lawns. I was talking to a manager just last night that there is a water district that is actually paying associations to kill their grass. They've adopted a resolution that says we will pay you X dollars or X amount per square foot of every square foot of grass you kill, and we don't have to water. I have not heard of anything else that extreme, but you're starting to see how the legislature and how the state is starting to look at lawns. So this merely goes and puts more meat onto this bone, if you will, of getting rid of your yards. So it starts. It amends 106.5 of the Colorado Common Insurance Spec. It has different standards for attached homes and unattached homes. It does not change anything having to do with condominiums. So on attached homes, you cannot prohibit the use of non-vegetative turf grass or drought-tolerant landscapes to provide ground covering to property which an owner is responsible to maintain. So if you have limited common element areas, or if you have townhome community that has a little backyard that has a fenced backyard, you cannot prohibit the installation of astroturf. You cannot prohibit the installation of artificial turf in the backyard, okay, in the backyard of those units. And you cannot prohibit the use of water-wise landscaping, non-vegetative turf grasses, or the like on those type of communities. So it's a minor change to the statute as far as townhomes, and it doesn't change anything in relation to condominiums. If you manage a single family detached community where I have a front, back, and side yard, this is where the majority of the changes lie. And this is where you as a manager, you as an association are required to adopt a xeriscaping policy. And the xeriscaping policy must contain certain things. But again, what this bill does, it says the use of xeriscaping, non-vegetative turf grass, or drought-tolerant or non-vegetative landscapes to provide ground cover to property for which a unit owner is responsible, including limited common element or property owned by the unit owner, and any right-of-way or tree lawn that is a unit owner's responsibility to maintain. So we're back out into tree lawns that the owner must maintain. You association may adopt and enforce design or aesthetic guidelines or rules that apply to drought-tolerant vegetative, non-vegetative landscapes or to vegetable gardens, or that regulate the type, number, and placement of drought-tolerant plantings or hardscapes, but you cannot deny them. And also, not prohibit the use of non-vegetative turf grass in the backyard of an owner. So that stays put, okay? Non-vegetative turf grass, artificial turf in the back. Great fun. It's protected. Means you should probably adopt a definition of what the backyard is, but that's okay. That's solid. You can no longer unreasonably require the use of hardscape on more than 20% of the landscape area. You should probably define what hardscape is. You cannot require it on more than 20% of the area, and you cannot require more than 80% be vegetative plantings. So it's an 80-20 rule, okay? Hardscapes, usually that is concrete, pavers. If you want to include all rock in hardscapes, that's fine. That's why you've got to adopt these policies regarding what exactly you're considering hardscapes, how far do you want to push that boundary, and then allow a unit owner an option that consists of at least 80% drought-tolerant plantings. So you have to allow at least 80% drought-tolerant plantings. Where this is going, my friends, ladies and gentlemen, is you can no longer require grass of any level. Just take grass off the board. It's gone. Okay. You cannot prohibit vegetable gardens in the front, back, or side yards of a unit owner's property, which is, again, why I think you probably need to get a definition of what the front, side, and backyards are. Because the legislature has said you have to make definitions of what the side yard is, what's the backyard, what's the front yard. Make these definitions. For purposes of this subsection 1.5, the association shall select at least 3 pre-planned water-wise garden designs that are pre-approved for installation in front yards within the common interest community. You have to go to the Colorado State Extension University plant selection organizations, downloadable designs, and you must download at least 3 that I, as an owner, can go to your website, say, ooh, that's pretty. I want to install that. And I don't have to go to you for approval because it's pre-approved. All right. And then the other one that loves this is if I cannot go out and if I cannot find the plants on that pre-approved plan, I must be allowed reasonable substitutions. So I would highly advise all you wonderful folks in single family detached communities define what a reasonable substitute is. I had a discussion with another attorney in my office. If the vegetable garden calls for corn, or if the vegetable garden calls for carrots, can I plant corn? They're both vegetables. I would argue no. It's not a reasonable replacement. So go in there, having all sorts of fun with this one again. If I want to put a garden in my front yard, you have to allow it. It can be a vegetable garden. It can be a pollinator garden. It can be a flower garden. It can be leafy vegetables or leafy greens. So I can plant my rutabaga, my lettuce, my carrots, and then I can plant pollinating flowers all around them. Okay. For the purposes of this subsection 1.5, each co-association shall select at least 3 approved. Okay. Remember, my friends, you cannot prohibit vegetable gardens in the front, back, or side yard of a unit owner's property as used in this subsection. Vegetable garden needs a plot of ground or elevated soil bed in which pollinator plants, flowers, and vegetables, or herbs, fruits, leafy greens, or other edible plants are cultivated. All right. This statute, this particular area, can you plant pot? Mary, I'm not answering that question. No, is pot a leafy green? It is. Okay. All right. Here we go. The use of xeriscape, non-vegetative turf grass, or drought-tolerant plantings on landscaping is to provide ground covering to property for which a unit owner is responsible, including limited common element or property owned by the unit owner in any right of way. So in answer to your question, this doesn't apply to associations where the association maintains the front yard. No, it applies. I own it. I can do what I want with it. You cannot restrict me from doing it. Now, if I do this stuff, it's mine. I own it. I have to maintain it, but you can't stop me. Okay, let me go up and answer some of these questions just for fun, because that's how I roll. Wait, time out. Let me see. Let's go. Let's do this. Where did I lose track? You guys just went off, and I love it. Okay, here we go. Does that mean they can do all rock? No, it doesn't. But they can do up to 20% rock. Susan, when you can, please remind us what is already in place for the townhomes and paired homes, not part of the statute. True. It's the paired homes. You can't prohibit artificial turf grass in the back, but that's really the only change to this particular statute. That it didn't get into this. If you live in an attached product, it did not go that far. It really is the use of xeriscape, non-vegetated turf grass, or drought-tolerant vegetative landscapes to provide ground covering to property for which a unit owner is responsible, including a limited common element or property owned by the unit owner owner. Associations may adopt and enforce design guides for aesthetic guidelines or rules that apply to non-vegetative turf grass and drought-tolerant vegetative landscapings, or regulate the type of the number of the placement of the drought-tolerant plants. So again, a townhome and attached product, I can go xeriscape it if I'm responsible for it or if I own it. But you don't have to allow the vegetable gardens. Okay. All right. What about the front yard? When does this take place? This takes place, hang on, let me see. It takes place August 8th, August 9th. And I haven't gotten to the real kick in the teeth just yet. Okay, with SB 23178, what kind of maintenance can you require? You can require aesthetic maintenance, and it still has to look good. You just have to allow the drought-tolerant plantings. Can you require approval of drought-tolerant? Again, Mary, can you require approval of drought-tolerant landscaping plans? Yes, if they're outside of the 3 pre-approved plans you are required to have. Are there any rules regarding vegetable gardens? No. Such as how much space can be used? No. Types of garden box used? Aesthetic. Ruling out certain vegetables that grow tall, such as corn? Pre-approved. If there are plans out there that have corn, you can adopt a plan that you could, the 3 approved plans, you don't have to allow corn. But if you adopt a pre-approved plan with corn, nope, got to allow it. What if the owner wants to keep grass, but they are not maintaining it or it's too sparse, bare dirt spots? Can the HOA require them to mow and or apply seed? Yes, you can. This does not. This bill says you can't prohibit installation of xeriscaping concepts, and you must allow vegetable gardens, and you must allow these things, but it doesn't say if I choose not to. If I want to keep my lawn, I still have to keep my lawn in good shape, unless there are drought restrictions, and if drought restrictions, then you can't find me. And you have to give me a reasonable amount of time to bring it back up to the luscious green area that it is. But no, allowing your yard to die is not xeriscaping. It has to be replaced with something. I heard the state wants to be notified of who has a vegetable garden. Is that true? That is not in the bill. But I have no doubt, Mary, that the HOA task force is going to come talk to you anyway about it. So, hey, why not? But no, it is not in this bill. Assuming that an HOA maintains the single-family front yards, that the association can still prohibit vegetable gardens? No. In areas maintained by the association? Nope, nope, nope. If I want to go destroy all the beautiful yard work you're doing, I can. Is it true that if the HOA is paying for the lawn maintenance, then this does apply? No, Janet, is not true. Can we require screening, vegetable screening? No, the vegetable garden is the screening. Who defines what drought tolerant? What is drought tolerant? The state does. We are getting requests to plant clover instead of grass, but there are differing opinions on it if it's drought tolerant. Go to the Colorado State University, Extension University, and pull up their list of drought tolerant plantings. Can you restrict the height plant? Guys, what is it with restricting height of plants? What do you care? Sorry, Jillian, but it's, and when I say that, I'm being a little facetious. I understand people may not want corn growing in their front yard, but if corn is a drought-tolerant planting, I don't think it is. I think it's water-intensive. But if it is in the list of pre-approved plantings, yeah, you have to allow it. You can't restrict it. But again, you are allowed to adopt 3 pre-approved plans and stick to those. Just go download those plans. Can you plant pot? Only if you want to. You can probably still restrict it because I'm going to go out on a limb and say, 1, pot is not a xeriscape concept plant, and 2, I can almost guarantee it does not appear on the Colorado State Extension University's pre-approved plant list. And that's, can we require vegetable screening? No. Where do we get the design? Colorado State Extension University. The actual statute does not state where the website is. Our policies, if you have us draft your policies, we've done the research for you of acceptable websites, but there are others. It's not exclusive. Can you require that setbacks be respected within the raised bed installation? I'm going to say no, you can't, because that bill doesn't say stick to setbacks. That bill says I can have a vegetable garden in my front yard. And it says that you can't restrict xeriscaping in the tree lawns. So I'm going to go out on a limb and say, no, if I want to put my vegetable garden right up front next to the sidewalk, I can. But again, if you are adopting plans, you should have some ability to say where they go and the size, but it's my friends, this bill is, you shall not effectively prohibit these things. Can you define an elevated garden material such as a small metal horse-style truck? Yeah, I think you can. Thank you. It's all right. Is it all right to have owners submit design review requests for ARC prior to installing the pre-approved designs? You know, you can establish, again, these criteria, and I think, yes, you probably can, because again, they can download the pre-approved plans, and the pre-approved plans are plant list. But as far as placement on the yards and the side yards, yeah, I think you probably can, but we're going to find out in a hurry. And the reason I say, yeah, you can, yeah, maybe, let me get to it in about 2 seconds. In addition to the 3 xeriscape designs, can they adopt 3 vegetable garden designs too? Yep. What about the associations wanting to require fencing or privacy screening around the garden? Nope. 2 questions, Holly. Let me see. Can we still require grass and tree lawns? Nope. And Holly, that was, oh, wait, there. Can we put restrictions such as 50% on the backyard must be live plant material? I use the 80-20 rule. It's 20% hardscape, 80% drought-tolerant plantings. So you can require up to 80% drought-tolerant plantings, live plant materials, yes. But it's got to be the xeriscaping concepts. You can't require turf grass. Mickey, coming back. What is the effective date of this legislation? August 8th. How will the task force notify HOAs of their meetings so that we can notify HOA members? It's a good question. We will stay on top of it. Will the task force have a website for public access? God, I hope so. Again, they're still figuring this out. Can HOAs prohibit greenhouses to grow plants? Yes. It says raised flower gardens. It does not say greenhouses. In cases where the HOA handles all the turf maintenance, including the irrigation, and pays the water, does the HOA have to allow owners to water their gardens? Yes. Well, it has to allow them to place the garden there. You can probably restrict them from using your water. That's a good question. Yes, the answer is nothing in the statute that says you have to allow them to steal water from the association. But remember, at the same time, Tyler, these are drought-tolerant plantings, so theoretically they'll use less water. And you control the water, so it may not, what their garden needs may not go with what your water schedule is, so it may not be in their best interest. Also about AstroTurf in the place of grass in the front yard, no. Artificial turf is not migrated to the front yards yet. Does this change if the city requires tree lawn grass? No. This overwrites anything for the tree lawn. It's flat out. Nope. You can xeriscape concepts in the tree lawns. Is there a flat fee for the altitude policy? Yes, there sure is. I'm going to misquote it, so I'm not going to let you know. I am sure Summer will pipe in and tell me exactly how much it is. What about chicken? Tina, chickens and chicken coops are not part of this legislation. That's next week's drill. No, chickens and chicken coops can still be regulated pursuant to your governing documents. Can associations do nothing to continue to maintain grass landscaping? No, they can do nothing. $495. Thank you so much, Jonathan. I will accept that as gospel. $495 for the policy. You are wonderful. Okay, moving on. And we'll come back to this, I promise. But I've only got 5 more minutes and I have another statute. Metropolitan Transportation District transparency. Any districts created after or filing service plans after a date certain, it's July. Wait for it. Oh, that's the insurance bill, which really didn't go as far as we wanted it to go. But the bottom line is, what this really says is, if the Metro District is going to issue additional debt, it has to disclose it in its service plan, how much debt and how much the mill levy can be to service the plan. But it also requires conducting an annual meeting of the voters for all residential units. One thing, again, the Metro districts had gotten out of is they don't have to have an annual meeting. They can just do an election. Not anymore. They have to require an annual meeting just like an association. It's great fun. That's the Metropolitan Transportation District. So if you manage a Metro district, you now have to have an annual meeting. Insurance, 1174. This bill was partial response to the Marshall fires. It did not go as far as the bill should have gone with any of you that are dealing with association insurance. It's not the one we'd hoped. It requires production of an independent third-party report for the cost of reconstruction of homes in Colorado. It requires a longer notice period if they're going to non-renew your policy, requires inflation protection coverage, requires increased law and ordinance coverage of up to 20%, requires additional notices as coverage is purchased and declined. So if you're not going to acquire certain coverages that are optional, you have to have those premiums laid out in your policy so you know exactly what you're foregoing, and then provide disclosure of a premium with and without the endorsements. This does apply to association master policies too. So it increases the non-renewals, it increases your law and ordinance coverage, and it increases a few other things, but it does not say they can't non-renew you. It does not cap how much associations can get charged for their insurance, and it does not create a state-run program. Sorry. All right. Let me see. Does this apply to street tree lawns? Basically, public rights of way? Sure does, because you cannot regulate the public right of way anyway, and now the city can't require grass in it. Since it's private, some of these are ridiculous. Man, you're not kidding there. Let me see, go back to, since the Metro District transparency is effective this August, does the first annual meeting have to be in 2023? Sure does. They must put it together. The date of actually putting together the HOA task force is not set forth in the statute, but the date they're putting forth the Metro District task force is. And the Metro District Task Force is required to meet this year. So I'm going to go out on a limb and say that's the same for the HOA Task Force. So I would think that if you guys just started notifying your associations now that this exists, and go to the Department of Regulatory Agencies, it'll probably have a schedule. But again, right now, this very second, they are not even created. So they obviously have not put together a meeting list. Okay, real quick, look into the future. And I have 2 minutes. Thoughts for the future by looking at the past. If you remember last year or the year before, Representative Titone put in presumed damages for records up to $500 if you do not provide records in a timely manner. The xeriscaping bill contains the exact same provision. Up to $500 of damages per impacted owner if I don't approve, or if you don't approve a xeriscaping plan, or if you are not complying with this statute, there are presumed damages of $500. In looking at this, I think you are going to start seeing bills produced that have damages or presumptive damages against associations for failing to comply. And I think associations are going to start being fined $500 a crack for not giving records, for not adopting your policy on xeriscaping, for not adhering to your policy or trying to make it more difficult for owners to install these xeriscaping concepts. I think they are going to have claims of presumptive damages of $500. Task force, they're looking at homeowners' rights. It is geared towards homeowners' rights, not towards association operations, not towards how better and more efficiently to operate an association, but rather how we as associations are mistreating owners. I think this is going to be calls to carry this over. Who are they really looking out to help? There are calls to quote unquote end evictions in the state of Colorado in the next 2 years. Does that mean we're going to end foreclosures of association liens if they fail to pay? I don't know. Who's the fine paid to? It's paid to the owner. The owner's damages from the association's coffers. You're going to see a whole slew of niche demand letters. You didn't let my client install xeriscaping, therefore $500. And then is Kiowa replacement going to be out there? Can HOAs limit the number of approved plans, or do they have to approve all? They have to approve all plans submitted. They can limit the number of approved plans. Kind of like different elevations on homes. You have to adopt at least 3 pre-approved plans, but once those are adopted, you cannot stop 100% of the community from installing them. Betty, sorry to be challenged, but does this new xeriscape policy apply to any xeriscape design review request that is currently being considered? No, but again, come August 8th, this bill becomes effective. You have to have your policies and procedures in place at that time. Thank you, everybody. It has, as always, been an absolute pleasure. I love working with you. I love these little chats we get to have in the middle of the summer, telling you just how busy your summer and falls are going to be. I'm so excited. All right, Rachel, can we require no number 2 yards next to? Yes, I think that you probably can, which is why you have to have 3. You can kind of, again, see everything doesn't look the absolute same. I think you can say, no, you can't have number 2, you can have number 1. But again, I think in all reality, it's not going to matter. I really don't. So you should probably just let them run with it. Bye, everybody. We'll talk to you soon.